Have you ever heard of something called the implied immunities of governmental instrumentalities? In 1904, the High Court of Australia established that as one of the most fundamental principles of the Australian Federal Constitution. And this will be the theme of our video today. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will analyze a case called Yamden and Pedder from 1904. In that case, the High Court of Australia established the doctrine of implied immunities. Come with me and let's find out what that means. Let's start with the facts of the case. The state of Tasmania had a law that required the payment of stamp duty on receipts that were signed by the employee every time they received a salary. Mr. Yamden was an employee of the federal government who lived in Tasmania, and in March 1903 he refused to pay the stamp duty on his salary. So a whole situation came out of there, and the case ultimately went to the High Court of Australia. The question before the High Court was, should Mr. Yamden pay the tax on his salary or not? Unanimously, the three justices of the High Court decided that he shouldn't. And this is why. The High Court of Australia found that a federal Commonwealth officer was not obliged under a Tasmanian statute, under state law, to pay a tax on his salary. They agreed with one of the arguments presented by James Drake, who was the Attorney General of Australia at the time and who represented Mr. Yamden. The argument was that that stamp duty was a tax imposed on a federal Commonwealth, on a department of the federal government, therefore in an instrumentality of the government. So the Tasmanian law affected departmental affairs of the Commonwealth government. And if that was the case, what it meant was that that stamp duty, if paid, it was a tax on the federal government, on a department of the federal government. And that is unconstitutional, according to Section 52 of the Australian Constitution. Because let's go back to Section 52 and take a look at it. We already saw it before, but it gives exclusive powers to the federal parliament. If we accept that a Tasmanian law, the Stamp Duty Act, was applicable to a department of the federal Commonwealth, we're going in a contrary sense to what the Constitution established, because Section 52 said that the matters relating to departments of the federal government were matters exclusive for the federal parliament, for the Commonwealth to legislate about. So to that extent, the Stamp Duty Act was unconstitutional because it was being implemented, it was being applied for a department of the federal Commonwealth, and the states cannot legislate about that. So this case established that Commonwealth departments, offices, the government instrumentalities were impliedly immune from state legislation. There is an implied impossibility of the states to legislate about certain matters that belong to the federal Commonwealth. The reasoning of the High Court went this way. The states have a kind of sovereignty. They're separated, they are independent from the Commonwealth. And if that's true, then there are certain things that the states can do and legislate about that do not concern the federal Commonwealth. And on the flip side, the same thing will happen. There are certain things that the Commonwealth can do and legislate about that the states cannot. So the Commonwealth is also sovereign in a certain way, and it is separated and distinct from the states. And we have already seen that there is a coordination between the states and the federal Commonwealth in the Australian federal system. If you want to check more about that, just click on the top right corner and watch the videos on that playlist. So the reasoning went on to say, well, if the two levels are sovereign, if the Commonwealth is sovereign and if the state's sovereign, then each one has the power to impede the other from entrenching in its own structure. Each level of government has the power, the possibility of dismissing the others if the other is trying to control them. This is a principle called the implied powers. This principle became particularly known after a case called McCulloch and Maryland in 1819 from the United States of America. This is what the principle of implied power says, that when the law gives something, it also gives that without which the thing given would be valueless. Let me translate that. If you are given a right to do something, the implied powers says that you also have all the powers that are necessary for you to do that something, for you to exercise that right that was given to you. So basically the argument is, if we say that a state is sovereign or that the Commonwealth is sovereign, then to allow for them to be sovereign, we have to give them the powers necessary to guarantee that sovereignty. That is, they can dismiss the attempts by the other levels of government of trying to control them, of trying to diminish their sovereignty. So what the High Court said was that if the state and the Commonwealth are sovereign, they are able to exercise their legislative powers immune from the operation of the legislation of the other levels of government. The states can disregard the laws of the Commonwealth, or vice versa, if those laws attempt to diminish or interfere with the state's sovereignty. This principle, as established by the High Court of Australia in this case, is known as the implied immunities of governmental instrumentalities, or implied immunities, or implied immunities of instrumentalities, or immunity of instrumentalities, or immunity of governmental instrumentalities. You got the point. In a nutshell, the principle or the doctrine of implied immunities asserted that the states and the Commonwealth were immune from each other every time their legislation tried to interfere with their own governmental instrumentalities. The states cannot interfere with the departments and the offices of the Commonwealth, and the Commonwealth cannot interfere or attempt to interfere by legislation with the governmental instrumentalities of the states. In 1904, another case confirmed this, was called Deakin and Webb. But also some other cases later on also said the same thing and confirmed this doctrine of implied immunities. The cases were the Railway Servants case in 1906 and the Baxter and Commonwealth in 1907. But this principle found its demise in 1920 when the High Court of Australia decided a case that is known as the Engineers case. If you want to know more about the Engineers case, you're gonna have to subscribe to my channel and also hit the bell sign, because my next video will have everything you need to know about the Engineers case of 1920. I hope you enjoyed this video. If you did, don't forget to leave a like, and I hope to see you next time when we're talking about the Engineers case. Until then, ciao.